Welcome back. We are back. The internet allegedly is fixed, so we'll see if that's actually true. They sent an email out saying, or actually a text saying it was all good. I guess only time will tell. But at any rate, we're back for part 2 of Kelsey Fitzsimmons and this tragic case. And let's keep rolling. What do we got next?
Yes, if you are starting this wondering, what do you mean part 2? Hop out, watch part 1 until our internet goes down, and we're going to pick up with part 2. So after the judge just shockingly out of the blue says, all right, conditions of release revoked, my prior order revoked, you're back in jail, you're going to tell me it's cruel and unusual punishment? You gave me no choice. Back in jail she goes. The lawyers file motions to reconsider. And I'm going to start there. Let's see.
Yeah, and while you're pulling that up, it's very rare that a motion to reconsider is granted, because essentially you're asking a judge to go and change their mind on what they originally ruled. And short of you pulling up some kind of case law that they just completely shit the bed and just did not apply the law correctly, short of a situation like that, you know, they're typically going to deny it, because judges don't like to admit that they fucked up. That's facts. So I'm sure nobody was surprised by what happened with this.
I'm sure there is some surprise given her order, but so I'll read this one, you'll read the supplement. So motion to reconsider imposition of custody and for reinstatement of original terms of release with order for alternative alcohol testing. Now comes Miss Kelsey Fitzsimmons, defendant herein, and respectfully moves that this court, I don't know how we ended up with that arrow, but that this court reconsider its revocation of her release and instead impose available alternative alcohol testing by random urine tests as set forth in the attached email provided by probation. I don't think I have the attached email, so I don't know if it exists out there, but I haven't seen it. As grounds therefore, the defendant respectfully states that returning her to prison is not the least restrictive alternative to effectuate the court's aims and concerns regarding alcohol testing. Instead, the court can order an alternative to SCRAM testing, whereby the defendant submits random urine tests to the Aver Health contractor as set forth in the attached email from the probation department. Undersigned counsel has been informed by probation that there is a testing facility approximately 10 minutes from the defendant's residence on Essex Streets in Lawrence, where she can be driven as per the court orders to be tested in a random fashion. The random testing involves the probationer calling every morning to see if she is required to go to the facility for random testing. Her mother or father are available to transport her to that facility where the testing requirement is invoked. See email from probation department, attached here to setting forth alternative urine screens at AverHealth vendor in Lawrence, Massachusetts. Now, I just don't know why we're citing an email when the judge said she won't consider an email without citing to a mistake of law on the part of the judge. She was mistaken in failing to consider the email because it's hearsay, and hearsay is admissible at pretrial hearings. Like, I don't know why there's none of that right here at this point in time. Why it's just, hey, look at this email you said you wouldn't look at before. The court can accomplish its goals with this alternative rather than incarceration and without causing Ms. Fitzsimmons undue pain. Undersigned counsel has been informed by probation that this testing method is available in this court, in this case. Now, again, in Illinois, and I think I've even seen it in the Karen Reed case, I would have done this as a verified pleading, meaning that the lawyer is swearing to the facts asserted therein. The court can accomplish its goal with this alternative. Oh, sorry. Thus, the court may order a less restrictive alternative than incarceration that completely addresses the court's concern over alcohol use, the safety of the community, and any person without the severe alternative of incarceration. Defendant presented to the court that attempting and completing the SCRAM caused pain at the time, as well as 3 to 4 hours thereafter. The court acknowledged she did not want the defendant to be, quote, tortured, but did not consider other alternatives that would accomplish this goal without pain to the defendant. The court's revocation of all conditions to send the defendant back to jail is worse by far than even requiring her to submit to SCRAM. Aside from her total loss of liberty, the defendant is a police officer and former correction officers who would face serious risk of bodily harm in such facility. Ms. Fitzsimmons is requesting why can't I speak? Babe, where are you? An expeditious determination of this issue and does
Expeditious.
oh my God. An expeditious determination of this issue and does not request, what did I say? Expeditious?
It was whatever it wasn't right.
Determination of this issue and does not request an in-person hearing. Defendant requests an expedited response from the Commonwealth reporting their position to the court consistent with the case law, provided that, quote, relief in this type of case must be speedy if it is to be effective, citing a United States Supreme Court from 1951. Conclusion: for the foregoing reasons, Ms. Fitzsimmons respectfully asked the court to reconsider its order of incarceration on this date and return her to house arrest with the same condition as ordered, accepting a random urine requirement as requested above in lieu of SCRAM. Wherefore, the defendant respectfully requests the court issue appropriate orders in the interest of justice as set forth. Okay, so now he just says that this risks her to risk of bodily harm in such a facility. He knows that this judge will not make any reasonable inferences from facts, such as cops are at risk when they're in jail. I mean, that is something that she can reasonably infer from the facts, but I would have gotten something from the jail saying that we recognize that former police officers and former correction officers are at risk of serious bodily injury or harm in this facility. It is something we've seen in the past. We would have to put her into, isolation, and then they could argue how that isolation is not good. She shouldn't have to suffer that. That's also extreme. I just don't know why you're not putting forth any more actual evidence that the judge wants. Why not have an affidavit from probation attached, an affidavit from the jail attached? Something like that. But then they also do a supplement to
All
the
right, I'll pull that up.
It's up. You can read.
Oh, okay. It's kind of small for me. Now comes the defendant, Kelsey Fitzsimmons, and respectfully files the attached doctor's letter from Jonathan Parks, MD, the trauma surgeon that attended to Miss Fitzsimmons during her stay at Mass General Hospital. In the hearing that preceded the pending reconsideration motion, the court expressed its concerns that it desired medical evidence relative to Ms. Fitzsimmons' condition and on the assertion that her broken rib could impede the deep breathing necessary for the SCRAM device, causing pain and trauma to the defendant. The defense has obtained a letter from her surgeon addressing these concerns, corroborating Ms. Fitzsimmons and her mother's previously filed affidavits, and files a true and accurate copy herewith.
I'll read the footnote since it's small. The Supreme Judicial Court, quote, has always allowed the use of hearsay at probation revocation hearings. Thank you. Commonwealth v. Durling. Also, Commonwealth v. Calvo. Unavailability of witness not required to be shown for admissibility of reliable hearsay. The revocation process, quote, should be flexible enough to consider evidence, including letters, affidavits, and other material that would not be admissible in an adversary criminal trial. Morrison v. Brewer. Similarly, the Supreme Court has sanctioned the, quote, use where appropriate of the conventional substitutes for live testimony, including affidavits, depositions, and documentary evidence. Thank you for citing the law, because this judge seems to pretend she doesn't know it.
Okay, so back to the body. There is no request for impoundment. Wherefore, the defendant requests that an alternative means of alcohol testing be implemented, such as urine testing, at the Aver Health Systems, a Commonwealth vendor, 10 minutes from the defendant's.
Oh, sorry. Forgot that you're relying on me.
Next page. 10 minutes from the defendant's family residence, and the defendant be returned to her previously allowed terms of release.
All right. So I just want to note, because I didn't see this, or I didn't look, and it might have very well. Okay. So on the motion to reconsider and on the supplemental, there is an affidavit of counsel. So that does rectify my issue, what I said earlier. So on the main one, he says that he states under pains of penalty that the foregoing facts in this document are true and correct. That should be sufficient. Same thing with this affidavit. On oath, I do hereby certify that the attached document is a true and accurate exhibit as provided by Massachusetts General Hospital to the defense team, to the best of my knowledge and information and belief. So here is the letter, and it is dated September 15th to the Honorable Court, and has her name, and I should try to get rid of her date of birth there. I was the trauma surgeon on call when Miss Fitzsimmons was admitted to Massachusetts General Hospital with multiple gunshot-related injuries. Her documented injuries included: 1, gunshot wound to the right hemithorax with retained bullet fragments in the right upper back. 2, moderate right hemothorax requiring chest tube placement. 3, right middle and lower lobe pulmonary contusions with active bleeding. 4, grade 4 hepatic trauma with active bleeding from the right hepatic lobe. That, I don't think I'm saying that right.
I agree, doctor. I think you're probably butchering that.
All right. 5, comminuted. Wait.
That might be right, though. Hepatitis, hepatic. I don't know.
Right.
Maybe. Could be.
All right. Right posterior 12th rib fracture. 6, right anterior 11th rib fracture at the costochondral junction. Her treatment course included multiple procedures, including chest tube placement,
percutaneous
drainage of a hepatic collection. I mean, Jesus. The ERCB is that biliary?
I don't know. I'm just glad you decided to read this letter instead of my
placement. In my medical opinion, A fracture of the 12th rib can cause pain that may persist for several months after injury. The severity and duration of the pain following such a fracture vary, and it is difficult to predict how long symptoms will continue in any given patient. Additionally, retained bullet fragments can also cause chronic pain that can be exacerbated by movements such as deep breathing. Please contact me with additional questions or concerns. Now, I don't know how long it takes for a fractured rib to heal, and maybe that if that's something longer than the amount of
Hot
time,
minute, I imagine.
right, that maybe that could have been mentioned here. Um, but so be it. He's got a sworn affidavit here that puts forth that the the um the alternatives that are available. He's got a sworn affidavit that this is a letter from the doctor. Um, and now let's go to the judges. Do you want to put this up yourself so you can read it?
The order? Yeah, 'cause
Yeah.
it's gonna be my last act, and then I've gotta leave you. I've gotta leave it all in your capable hands. So, all right,
I'll take
'cause
it down.
this traffic looks shitty. All right, so now we're gonna go to the judge's order, okay? And she had things to say, as you can imagine. Old Judge Fussy Birches just had all kinds of shit to say. So, this is the order on defendant's motion to reconsider imposition of custody and or reinstatement of original terms of release with the order for alternative alcohol testing. Okay, so the defendant, Kelsey Fitzsimmons, stands indicted for one count of assault with a dangerous weapon following 3 hearings in 2 weeks regarding conditions of release pursuant to GI 276, Section 58A to B. This case is now before the court on Fitzsimmons' motion to consider imposition of custody and reinstatement of original terms of release with order for alternative alcohol testing, hereinafter known as the motion, paper number 24. As there is nothing in the motion that was not known to Fitzsimmons and her counsel when this matter was last before the court on September 11th, 2025, there has been no change in circumstances or newly discovered information that would warrant revisiting the court's the court's decision. I know you have something to say about this.
Yes, I do. So I think that they should have put in their motion that, because someone mentioned earlier on the part one of this that this motion wasn't scheduled to be heard that day and the judge called them in. If that is the case, he should have put that in the motion that he had attempted to get, this letter, was unable to get it before it's dated the 16th, so was unable to get it on the day of the hearing, and something to that effect. But also the other, and the judge is going to contradict herself in the preceding sentences here about that it needs to be a change in circumstance or newly discovered information, or that they were aware of something now that they didn't know then. But what the judge is saying is, you knew all this stuff then. This isn't new information to you. You just didn't present it to me in the way that you should have at the time that you should have, is what the judge is saying here. And again, she's going to contradict this contradict this
Okay.
position.
I was thinking, is contradict a new word? So as explained below, Fitzsimmons' failure to transparently provide information related to her ability and willingness to abide by the conditions imposed despite 3 lengthy hearings is a manipulation of this court's efforts to fashion the least restrictive conditions of release that would both allow her to avoid incarceration and reasonably assure the safety of all other persons in the community as required by Section 58A. Thus, the motion is denied.
I just don't know what does she mean by that? That this is a manipulation. Well, every time I craft the least restrictive, they come back and say they need something even less restrictive. So that's a manipulation. How were they supposed to know before she was had the installation and the test breathing, that this breathing was not going to be able to that she wasn't going to be able to do it without severe pain. What is the judge talking about?
I don't know. And Nina, I agree, but I don't, because as we
I
stated, like
agree.
look, Bradel should have had all his ducks in a row. However, in that situation where you're calling up your opponent on the other side of the aisle and saying, "All right, I filed this motion. I realize I didn't give you all much time. Do you guys have any beef with it?" And when the Commonwealth's prosecutor saying, "No, I mean we're cool with it," he's going in thinking that if the state isn't objecting to what he's filing, that he's not going to get resistance from this
From the judge.
judge. That was his issue. Like, he
And
misjudged the judge and what her response would be. I don't know if Bradel has not been in front of her before. It seems like if Bradel's been in front of this judge before, that he should have known. But
it seems like she'd be giving him a little more deference. She's giving him no deference. She's
none.
being like, but the other thing, Nina, is that on the first part of this live, someone did say in the chat, and I'm not able to confirm it one way or the other, but that Bradel didn't set the hearing for that day. The judge called them in after he filed it, and the hearing was not expected, so he wasn't as prepared. If that were the case, I would have expected or hoped that he would have included that in his motion to reconsider, why he couldn't get this information to her before.
Okay, so after and this is the background, after the Commonwealth moved to hold Fitzsimmons as, quote, dangerous pursuant to GLC 276-58A, the court concluded, following a hearing on August 28th of 2025, that the Commonwealth met its burden as to dangerousness, and that Fitzsimmons' release on personal recognizance alone would not reasonably assure the appearance of the defendant as required, or would endanger the safety of another person, P.O. Noonan, or the community. Rather hold Fitzsimmons in custody. The court
Rather than hold
Fitzsimmons in custody, the court sought to fashion the least restrictive conditions of release that would reasonably assure her appearance and the safety of all other persons in the community as required by statute. So, based on the serious nature of the allegations against her, as well as evidence presented by the Commonwealth about Fitzsimmons' history of aggressive behavior while intoxicated, the court concluded that the condition of remaining alcohol-free and submitting to SCRAM monitoring was necessary to ensure the safety of the community, and imposed that as a condition of release. The court imposed a number of other conditions, including GPS monitoring, that Fitzsimmons reside with her mother and stepfather at their home under house arrest, and that she have no contact with the victim, any witnesses, or her child. After a further hearing regarding conditions of release on September 8th of 2025, Fitzsimmons was released from custody.
I just want to chime in right here. Why in the hell, without a hearing where there's only been an emergency order of protection entered, meaning no opportunity to oppose the facts, no opportunity to see, does he have the evidence to back this up? Are there other facts the court needs to consider? Is she saying no contact with her child? That is fucking outrageous.
Fucking outrageous. In the 3 days
there hasn't been any evidence. There's it's just words right now.
He's a judge who's electing to err on the side of caution, which is fucking,
not caution that the child needs the mother.
I get it in most situations. This one is fucked up because of the lack of any competent evidence that she was in any way, shape, or form a danger to her child. You will see in these types of cases where you have DV that's kind of floating out there in the ether, and they're coming in on these orders that judges, instead of them sitting on the bench and not issuing the order or letting her out on bond when she's not able to follow the conditions, that she's going to be, you know what, fuck it, I'm not going to be the judge who's sitting on this bench, and then she goes off unhinged and fucking does damage to somebody. Like, judges tend to err on that side, and that's true in our state as well. And I mean, I
this is the fact pattern for it.
This is not the fact pattern for it. There has been no competent allegations, no competent evidence that shows she was in any way, shape, or form a threat to her child. So, that as far as he goes, as far as Justin goes, fine. But in terms of ripping her away from her infant child, who
Not even
clearly
supervised visitation.
nothing, it's
I mean,
crazy,
that's outrageous.
outrageous, and because it's punishing not only her, who sits there as a presumed innocent person,
Right.
but more importantly, the baby. The baby is not with mom. The baby's not getting breast milk. The baby's not getting the care and the love and the nurturing from mom. All those different things, and those will have effects on the
Yeah.
baby long term. And we don't even know what it's going to be, but it's fucked up.
Yeah.
Like it's super fucked up. Okay, so in the 3 days that followed, Fitzsimmons requested relief from two of the conditions of release to which she had just agreed. First,
This is
immediately.
outrageous to me. This is she requested relief. Let's see. Yeah, first, go ahead.
So first, immediately after the September 8 hearing, defense counsel requested that the GPS condition be lifted so that Fitzsimmons could undergo surgery the next day on September 9th of 2025, with no evidence to support the contention that Fitzsimmons could not wear a GPS device during surgery, and based on probation's representation that a GPS device does not always need to be removed for surgery, the court denied this request. It's fucking
So
insane.
stupid.
It's
But
insane.
again, that right there having happened should have clued the lawyer into the fact that this judge needs the evidence in front of her. She's not going to make common sense, logical inferences. Like that should have told him right there, because that's ridiculous.
Hey, can you pull this up? I got to go. Traffic is hellish and I got to make it to the city. I'm on page 3. I'm going to listen to you as I'm driving, stuck in
Oh,
traffic.
so you're saying that you got me on watch?
Hardly. I'm going to listen to your golden pipes and your incredible legal brilliance and make the ride go shorter, maybe. All right. I love you all. I'll check you guys out in chat, even though I shouldn't be chatting and driving. All right. Love you, babe.
Love you. Oh, we were reading the judge. That's right. Okay.
Yeah, the order.
Okay. So this is where we ended, with no evidence to support the contention that Fitzgerald could not wear a GPS device. 2 days later, Fitzsimmons, did I just say Fitzpatrick again? Fitzsimmons filed an emergency motion for immediate relief from SCRAM order, which sought relief from the court order requiring her to breathe into a SCRAM device because Fitzsimmons was, quote, unable to do the testing without experiencing severe abdominal pain and dizziness, and because, quote, the breathing necessary to the task is impossible in her condition and impairs healing of her broken ribs and punctured lung. At a hearing on that motion on September 11th, 2025, counsel argued that it would be, quote, cruel and unusual punishment, close quote, and, quote, torture to continue to require Fitzsimmons to comply with the conditions of being monitored by SCRAM, but presented no alternative testing options to ensure Fitzsimmons remained alcohol free. And we have already sort of criticized that decision. Faced with counsel's representations that Fitzsimmons could not comply with SCRAM testing, a condition that was critical to the court's decision to release her on conditions and in lieu of incarceration, the court vacated its prior order of release and ordered Fitzsimmons held without bail pursuant to statute. Discussion. In the specific context of persons held pursuant to statute, quote, the hearing may be reopened by the judge at any time before trial or upon a motion of the Commonwealth or persons detained if the judge finds that, one, information exists that was not known at the time of the hearing, or that there has been a change of circumstance. Neither of those exist here. And two, that such information or change of circumstances has a material bearing on the issue of whether there are conditions of release that will reasonably assure the safety of any persons of the community, citing to the statute. More broadly, now this is where I said she literally, the judge just contradicts herself. More broadly, Massachusetts Rule of Criminal Procedure 13A5 empowers a judge to consider any pretrial motion which has been heard and denied upon a showing of substantial justice. In this case, there is nothing in the motion that was not known to Fitzsimmons when this matter was last before the court on September 11th, 2025. However, Rule 13A5, quote, is not limited to instances where there are allegations of new or additional grounds that could not have been reasonably known when the original motion was filed. And she cites 2 cases for that. Instead, a judge always has the power to reconsider his or her own decisions during the pendency of the case. Hello, judge. What, you're saying this, so why does it matter that there's nothing new? You just said it. You always have the power to reconsider. Cites a case for the proposition that, quote, judges are not condemned to abstain from entertaining second thoughts that may be better ones. Ultimately, whether to do so is not a matter of judicial discretion. Whether to do so or not is a matter of judicial discretion, and reviewing court will disturb a judge's decision on a motion pursuant to 13A5 only where there has been an abuse of discretion. I think there's been an abuse of discretion. I think there's been an abuse of discretion, and I will be shocked if a higher court does not find an abuse of discretion here in this situation. Going back to the order, Fitzsimmons' pending motion asked the court to, quote, reconsider its revocation of her release and instead impose available alternative alcohol testing by random urine tests as set forth in the attached email provided by probation, end quote. That attached email was purportedly sent by Assistant Chief Probation Officer Jeff January at 6:21 p.m. on September 10th, 2025, the day before the hearing on Fitzsimmons' emergency motion for immediate relief from SCRAM order. The email notes that the, quote, only alternative, end quote, to SCRAM testing is urine testing through a vendor called AverHealth, which would require Fitzsimmons, quote, to travel to one of the AverHealth sites to submit to a test. The email concludes by offering to provide, quote, more specific information on AverHealth tomorrow morning. Oh, Lord, I'm assuming I haven't read through this whole thing. I scammed the beginning earlier, but we can all see where it's going. Why in the hell didn't Bradel do this when he was in court and the guy was in court testifying? What is going on? So going back to the order, at the hearing on September 11th, the court gave the parties ample opportunity to present their arguments. Mr. January was present and testified under oath. For some reason, rather than bringing the alternative testing option to the court's attention and inquiring about it with Mr. January during his testimony before the court, defense counsel at that time sought only an order completely relieving Fitzsimmons of the condition of release requiring her to submit to SCRAM monitoring. Footnote 1, because that's not what I heard. So footnote 1 says, after hearing argument from the parties and testimony from Mr. January, the court asked defense counsel if he had anything else to submit. In response, he sought to admit into evidence the September 8th, 2025 email from Mr. January reporting his observations of Fitzsimmons during the SCRAM installation, but not the September 10th email from Mr. January or live testimony from him about alternative testing. Before taking a recess to reach a decision, the court once again asked defense counsel if he had anything else to submit, and he responded in the negative. Shortly thereafter, defense counsel vaguely suggested that there might be alternatives that might involve Fitzsimmons leaving the house for urine testing. So I take issue with this part of her order here. It wasn't vaguely suggested. He outright said it. Come on, judge. We all heard it. So continuing, but never provided the court with the information contained in Mr. January's September 10th email or any other specific information regarding an alternative testing option that would allow the court to assess whether such an alternative option was appropriate in Fitzsimmons' case. All right. Continuing with the body. It was only after the hearing when the requested relief was denied that defense counsel brought to the court's attention via the pending motion that Fitzsimmons could be tested for alcohol via a urine test performed by AverHealth. Rather than live testimony under oath from Mr. January on September 11th, defense counsel now asked the court to rely on an unverified email that provides little detail about AverHealth and the testing it offers. Footnote 2. The court declined to consider a September 8th email from Mr. January as evidence that the September 11th as evidence at the September 11th hearing on grounds that it was hearsay and Mr. January was at the hearing and available to provide live testimony under oath, while Section 58A provides that the, quote, rules concerning the admissibility of evidence in criminal trials shall not apply to the presentation and consideration of information at the hearing, and she cites to the statute, for otherwise inadmissible evidence to be admitted at a Section 58A hearing, it must be reliable, and there must be good cause for the decision not to present live testimony. Citing to a Massachusetts 2010 case, good cause can be shown in two ways. Quote, by presenting a valid reason for not presenting a live witness, or by showing that the proffered evidence bears substantial indicia of reliability and is substantially trustworthy. Both of which I think the substantially trustworthy part applies here. But what's irritating about this is the judge is going with form over substance. We're still talking about the unreasonable pretrial detention of someone who is deemed innocent. So substantial justice does require her to reconsider, and she shouldn't be playing games with, well, the lawyer messed up, so oh well, too bad, so sad. Moving back to the body. The motion also implicitly asked the court to modify the condition of release, placing Fitzsimmons on house arrest except for medical, court, or attorney visits with 48 hours notice to probation, as urine testing would reportedly require her to go to an AverHealth facility with less than 48 hours notice. The court points out that when it initially outlined conditions of release at August 28th hearing, the court specifically noted in the context of considering whether it was necessary to require random drug testing, the importance of minimizing the number of times Fitzsimmons was allowed to leave her residence. After being advised by probation that Fitzsimmons would have to leave the house for drug testing, and because it was an alcohol, not drugs, that were of concern in Fitzsimmons' case, the court declined to impose drug testing and imposed only alcohol testing via a SCRAM device because it could be done from the confines of the home. The court continues to recognize the importance of minimizing the number of times Fitzsimmons is excused from house arrest for the sake of assuring the safety of the community. Come on. I call bullshit on that. Come on. The court also notes that Fitzsimmons has had other opportunities to raise the issue of her inability to comply with SCRAM testing and suggest alternatives. The court first advised Fitzsimmons that her release was conditioned on being alcohol-free and subject to SCRAM testing at the initial 58A hearing on August 28, 2025. At that hearing, counsel asked questions and sought clarification about other conditions, but not about SCRAM testing conditions. All right, again, she did not know on that date that she was going to have this pain, dizziness, and issues with breathing into the SCRAM. The judge goes on to say, in addition, on September 8th, 2025, Fitzsimmons submitted to the court a medical notice, which the court impounded upon her request. Without revealing sensitive information, that pleading represents that Fitzsimmons has trouble breathing due to injuries sustained from a gunshot wound. Despite this, Fitzsimmons raised no concerns at the September 8th hearing about her injuries interfering with her ability to comply with SCRAM testing. Okay, maybe she thought she could power through it. Maybe she didn't realize just how bad and how long it was going to last and how much stress it was putting on her. Come on. The judge goes on to say, in sum, there has been no change in circumstance or newly discovered evidence that would warrant revisiting the court's decision pursuant to, again, that 58A statute. Footnote 3, the court acknowledges receipt of the defendant's supplemental exhibit filing on her pending motion to reconsider filed with the court on September 15th, 2025. It does not alter the court's decision. Okay. Nor has there been a showing that substantial justice requires it. Disagree, Your Honor. Ordering Fitzsimmons to remain alcohol-free and monitoring her for alcohol use with the SCRAM device was critical to the court's decision to release her on conditions in lieu of incarceration. Fitzsimmons has had multiple opportunities to advocate for conditions of release with which she could comply and which would satisfy the court's concern regarding safety of the community, as evidenced by the dialogue that has taken place between Fitzsimmons, the court, and probation over the course of the 2 weeks prior to the September 11th hearing. Her failure to transparently provide information related to her ability and willingness to abide by the conditions imposed despite 3 lengthy hearings is a manipulation of this court's efforts to fashion the least restrictive conditions of release that would allow her to avoid incarceration and reasonably assure the safety of all other persons in the community as required by Section 58A. So, guys, I mean, this is just ridiculous. This is really just ridiculous. This is a judge who is putting, as I said before, form over substance with why she's not considering this and what she needs to consider. She keeps falling back that this is not there's nothing new, and I don't know how she says that substantial justice doesn't require this. There are so many reasons that helping assist in your own defense, that pretrial detention, impedes on. I just wholeheartedly disagree with the judge's position in that regard. And she's just basically punishing the defense attorney for what she sees as not being prepared enough or ready enough or with what she wanted enough to reconsider her own decision. And it's really, really, I think, absurd. FKF 2025 says, this is still a language issue. DEF should not have asked to vacate the SCRAM order. DEF, he should say yes. That Kelsey Fitzsimmons agrees to the SCRAM device for GPS location monitoring, but needs an alternate method, an alternate alcohol monitoring method. And I don't know that if the SCRAM does provide is the GPS monitoring, but if that's the case, that's true. I also think he should have said, if Your Honor's unwilling to put this alternate, condition into effect, the defendant would rather struggle through the pain and discomfort than remain in custody. I mean, I don't know if that would have worked. How is Bob still here when he's gone? What's happening? Is he on his phone?
Oh yeah, I'm in studio. I'm just listening quietly though.
Yeah, but we see your logo face.
Oh yeah, pull that off. Unless
why you don't want to?
I want to jump on.
How will you tell us? No, just stay there so you can chime in. We love your voice and your opinion.
Okay.
Okay.
Oh, thanks, babe.
Nina says, just read the motion from the ex. He wants the house. We'll do that next. Music to My Soul says, Brado requested alternative testing during that hearing, but he didn't ask probation officer about urine testing because the judge was the one who questioned him. But Bradel should have questioned him. I'm sorry. There's no explanation for that in my mind. None. And the judge is saying he didn't try to get in the September 10th email about alternatives, which is what was, I guess, attached to that email that was attached to the motion to reconsider. I just don't know why he wouldn't have asked him about it. He literally said in the email, I can provide more information at the hearing, which also goes against what someone said before, that this hearing was unexpected because it said at the September 11th hearing. So it doesn't sound like it was all that unexpected. All right, so let's pull up the what did I do with it? Okay, so
there's two motions, right? You got both motions.
Right now I'm looking at a plaintiff's motion to attach real estate for the payment of child support. What else am I supposed to
Yeah,
add?
there's that one, and then there's another one.
Did you save it in Dropbox?
Tracy sent us. No, Tracy emailed them. Maybe she didn't send them to you. I'll forward you the other one.
Wait, this could be it. Let me see. I've got 135 is the yeah, I don't have that one. So yeah, send it to me and I'll start with this one that we do have. So this is a motion filed by her ex-fiance. Plaintiff's motion to attach real estate for the payment of child support. This gives you a window into the fact that this guy's a real piece of shit. I haven't read the whole, I've read like the first couple of lines, but I'm going out on a limb and saying it shows this, but I guess we should wait till I read it. But now comes the plaintiff, Justin C. Leon. I'm just going to say Justin. And pursuant to Mass Rule Domestic Relations Procedure 4.1, respectfully moves this honorable court to allow for the attachment of real estate in order to secure the payment of child support with regard to the above caption action. I hope he says, I am dirt poor. And between me and my family, we have no ability to support this child whatsoever. Before he goes asking the court to sell this woman's house out from under her to pay child support. Are you wholly unable to support your child? He's a firefighter. He's living with his parents. The family can't support them. They need her to have to force her to sell her house to assist with child support. Come on. So here's their brief background and relevant procedural history. The parties were never married and they have one child. Oh boy, 7 months. I'm gonna get that off screen because it's got her birthday. The parties lived together with the minor child on or about June 27, 2025, and provides the address. Mother is the sole owner of real estate located at an address, according to the registries of deeds. The father currently resides with the minor child at his parents' home. The father is a U.S. Army veteran and is employed as an EMT firefighter with North Andover Fire Department. Mother was formerly employed as a police officer at the North Andover Police Department. On July 14, 2025, mother's law enforcement certification was suspended. On or about June 30th, 2025, father sought to obtain an emergency abuse prevention order. That's what they call it there. Emergency abuse prevention order pursuant to statute from an Essex County probate and family court, granting father sole custody of the minor child and ordering mother to have no contact with father and the minor child. On or about July 1st, 2025, father filed a complaint for custody support parenting time pursuant to statute. On or about July 3rd, mother was criminally charged with 1 armed assault to murder, 2, assault with a deadly weapon, and 3, assault with a dangerous weapon. And he cites the criminal case. An extension hearing on father's 209A abuse prevention order against mother was scheduled for July 14th, 2025. On or about July 11th, 2025, mother, through counsel, requested a continuance of the 209A extension order, to which father agreed. A joint motion to continue was filed on July 11th, which was allowed. The court extended the order and continued it through August 1st, 2025. Now, that's not unusual, where they've got this temporary emergency order in place. It only goes for, as we said before, a very short period of time. That's why it was supposed to be heard on July 15th. So then they extended it to August 1st. On or about August 1st, 2025, counsel for both parties and father appeared for the extension hearing. The court's calendar could not accommodate a full evidentiary hearing, and as such, the court extended it and continued it till September 23rd at 8:30 at the Essex Probate and Family Court in Salem before the Honorable Mary Black. On or about August 7th, mother was arraigned on the 3 felony counts listed previously. On or about August 8th, father filed an amended complaint for custody, support, parenting time pursuant to statute. On or about August 25th, mother was indicted on a charge for assault with a dangerous weapon. And he again cites the criminal case. On or about August 28th, mother was released on bail to be set at personal recognizance. The conditions of mother's release were as follows: GPS in place, 24-hour house arrest except for medical, court, attorney visits with 48 hours notice to probation. 3, reside with her mother at their home. No weapons in the home. The CORI checks on all people in the homes. It's like a background check. 4, stay away, no contact with the victim and her child. 5, no alcohol with SCRAM. 6, sign any and all releases. And 7, follow the treatment plan by MGH. Again, citing the docket in the criminal case. On or about September 5th, mother was served with the summons and amended complaint for custody, support, and parenting time. On or about September 10th, mother filed an emergency motion for immediate release from SCRAM. On or about September 11th, the court issued an order on mother's emergency motion, which provides, inter alia, the court's prior order of release is vacated and mother is ordered held without bail. Again, citing the criminal case. On or about September 11th, mother filed a motion to reconsider the imposition of custody and for reinstatement of the original terms of release with order for alternative alcohol testing, citing the criminal docket. Argument. So section 2 is argument, legal standard pursuant to Mass Rules of Procedure. The court may authorize the attachment of real estate where there is a, quote, reasonable likelihood that the plaintiff will recover judgment in an amount equal to or greater than the amount of attachment sought, and such attachment is necessary to secure satisfaction of the judgment. Okay, that right there, this is not that. This is not that. You don't even have a support order yet, for God's sakes. You don't have a judgment that's going to be greater than the value of this woman's home. Well, let's keep reading, because maybe there's some other standards here that are going to shock me. Child support is controlled by GLC 208, Section 28, in the Massachusetts Child Support Guidelines, citing a Massachusetts 2006 case. In determining the amount of child support obligation or in approving the agreement of the parties, the court shall apply the child support guidelines promulgated by the Chief Justice of the trial court, and there shall be a rebuttable presumption that the amount of the order which would result from the application of the guidelines is the appropriate amount of child support to be ordered, citing Massachusetts statute. The Massachusetts Child Support Guidelines play a critical role in determining the amount of child support that is appropriate to keep the child as whole as possible. Public policy dictates that children are supported by financial resources of their parents, and child support guidelines are periodically reviewed to ensure consistency with these principles, citing a 2005 Massachusetts case. Massachusetts law emphasizes that dependent children should be maintained as completely as possible from the resources of their parents, reflecting the public policy of the Commonwealth. For example, the Supreme Judicial Court of Massachusetts emphasizes that the duty to support a minor child is statutory and has been recognized for decades. The court noted that both federal and state law provide the broadest possible support for minor children by their parents. Okay, so but you don't even know what she's got in her bank account. How do you know she can't afford to pay monthly child support? Necessity of attachment. There is a compelling and urgent need for attachment of real estate. They gave the address, standing in the name of Kelsey Fitzsimmons. As of June 30th, father has sole custody of the child pursuant to an abuse prevention order. Mother is ordered to have no contact. Mother has been indicted in Essex Superior Court on serious felony charges and is presently held without bail. Father has filed a complaint for custody support and parenting time. Hey, guess what, father? You got to wait until you get an order of support. Then she's in arrears of that support, and that arrears has either is the same value or exceeds the value of the property. What the flip is going on here? Sorry. Okay. Father has filed a complaint for custody support and
Tell him,
parenting
babe.
time. Yeah, thanks, babe. Pursuant to MGLC 209C, and as part of this action, father seeks the establishment and enforcement of child support obligations owed by mother for the benefit of the party's 5-month-old minor child. Given the facts and circumstances herein, there's a reasonable likelihood. What? A reasonable likelihood that father will obtain a judgment granting him both legal and physical custody of the child. Okay. The severity of mother's pending criminal matters on serious felony charge, combined with the abuse prevention order prohibiting all contact with the minor child, demonstrates that she is presently unfit to exercise custody or parenting time. This has not yet been determined in any hearing. What in the hell is? Am I missing something? Was there some sort? No, the hearing's set for September 23rd. Nothing has been done yet. Come on now. By contrast, father has been the child's sole custodian since June 30th and has taken necessary steps to secure secure custodial arrangement through his pending complaint. But you haven't done it yet. You've taken steps. Nothing's been secured yet, Jagoff. The totality of these factors strongly supports the conclusion that permanent custody will be awarded to father, thereby ensuring continuity of care and stability for the child. This is not covering what he wrote as the legal standard in the beginning to get this attachment order. It's like, what the hell? You're talking out of your ass right now. Despite mother's pending criminal charges, her duty and obligation to provide financial support for the minor child remains. Yes, that is true. At present, mother cannot work in any capacity. Yes, that is true. Further, upon information and belief, what information and belief? Mother does not have substantial assets but for the Phillips Brook Road property. Attachment of this property is therefore essential to ensure the child's financial security and to safeguard the child's best interest. No, you're taking 15 steps before you possibly could get to there. You need to have her in arrears already that she's not paying. Mother acquired title to the property by quitclaim deed or on or about June 27, 2023. Shortly thereafter, she obtained a mortgage in the amount of $388,000. They go on to say how many bedrooms it is, that the value of the property is now $599,000. This property constitutes the only known asset for mother with substantial value. Well, what kind of child support do they think they're getting? $600,000 child support? How long is it going to take for her to owe you $600,000 in child support, Justin? And what is wrong with the lawyer that filed this? Given mother's limited assets, minimal earning potential, it is highly unlikely that she'll be able to satisfy her child support obligation that hasn't been set yet. A child support obligation that has not been set yet through income alone. Didn't they say that child support is based on your income? If she's got no income, how in the hell are they going to require her to pay child support? Significantly, her law enforcement certification was suspended on July 14th. She also has been indicted. We got this, we got that. These factors further diminish her future earning capacity based on the $599,999,000 initial listing price and the $388 original mortgage. Mother's equity is $211,999. Footnote 1. Of course, this is all upon information and belief. The listing price in the property recently decreased to $579,000. Where were we? Okay, returning the body. By contrast, her projected child support obligation, even at the lowest possible attribution of income, full-time employment at minimum wage, $15 an hour, would amount to roughly $31,200 annually for the party's 5-month-old child. Over the next 17 years, this obligation at minimum is expected to total $530,400. What? Okay, then you wait until you get there. Once you get there, then you can attach her house. Because mother's equity in the property falls short of covering this long-term obligation, where's your law for this? This is not what you said the law was. This is ridiculous right now.
I've never heard of active child support ever.
What'd you say? Perspective?
I've never heard of prospective, meaning
right.
Future child support.
Right.
Yeah, you're right. All right. Sorry.
This guy's out of his mind. Crazy. Yeah. Because the mother's equity in the property falls short of covering this long-term obligation that isn't even set yet. It's a guess of her long-term obligation. It is essential that father secure an attachment on the full equity, $211,999, in order to protect the child's right to financial support. Oh, and deny the mother any ability to take the equity out of her home to pay her attorney's fees? Seriously? Is that's where you're going, huh? Accordingly, father respectfully requests this court authorize an attachment in the amount of $211,999, or the total net proceeds from the sale against the Phillips Road property. Without securing the proceeds of this real estate, there is a significant risk that mother will be unable to contribute in any meaningful way to support the party's child. Attachment of the property is therefore essential to preserve the only realistic source of funds available to ensure that the child's right to adequate financial support is protected. Wow. The court has consistently recognized that that the paramount interest of child support proceedings is the best interest and welfare of the child. Here, absent attachment, there exists a real danger that the sole asset available to the child's benefit will be dissipated or placed beyond the reach of the court. To avoid such an inequitable result and to secure the child's right to ongoing support, the court must authorize attachment of the Phillips Brook Road property in an amount sufficient to cover mother's anticipated future support obligations. This is just wrong legally in every single way possible. In every single way possible. This motion is further supported by such arguments that may be advanced by counsel at the time of hearing. Wherefore, father respectfully requests that there's an attachment. Wow. Ridiculous, outrageous. I just insane. Absolutely of zero legal. It's just all wrong. All wrong. All right. So what I got was a second email. Oh, no, sorry. Got it. Got it, babe. Okay. So now another motion that they filed yesterday, plaintiff's verified motion for temporary orders. Let's see if they're at least making valid legal requests of the court here, unlike that first motion. So, yeah, this guy's a real piece of shit. I mean, it's like you never loved this woman. You don't have a child with this woman. You don't recognize that whatever happened with your little 3 punches to the face was like, if that's even what happened. I mean, all right, now comes Justin, who respectfully moves this court to enter the following temporary orders: custody and parenting time. The father shall have sole legal and physical custody over the 7-month-old child. Child support, the mother shall pay the father child support pursuant to the guidelines. Health insurance, the father shall maintain medical insurance for the benefit of the child. Uninsured medical costs, the parties should split it 50-50. Child care, the parties should split it 50-50. Brief background and procedural history. The parties were never married. I'm going to, again, take out this information. This is the same background information that they put in before. So let's see what else they're asking for. All right. So the argument here is, in issuing any temporary or permanent custody order, the probate and family court shall consider evidence of past or present abuse towards a parent or child as a factor contrary to the best interest of the child, citing the statute. On October of 2024, while the mother was pregnant, the parties vacationed to Croatia with the father's parents and siblings. The mother behaved erratically throughout the trip and repeatedly expressed that she wished she had never gotten pregnant and threatened to kill herself, and leaving note that it was the father's fault. On or about October 5th, 2024, the mother became incredibly agitated, repeatedly expressed that she wished she had never gotten pregnant, and violently punched herself in the stomach. On or about October 11th, 2024, towards the end of the vacation to Croatia, the mother refused to engage with anyone, including the father. While the father attempted to discuss this behavior.
Are you saying Croatia? What?
Did I not say Croatia?
No, you said something else. Is it Croatia?
Yeah, it's Croatia.
I can't see it. All right, I was just making sure. Sorry.
When father attempted to discuss this behavior, the mother forcefully slapped him on the back. On the same day, while the father and mother were walking along the waterfront, the mother threatened to walk off the edge and drown herself. 4, the night the parties returned home from vacation, the mother was agitated, and the father attempted to engage in calm conversation regarding her behavior throughout the trip. The mother became erratic and began breaking pictures and glassware, knocking items off counters, and kicking and punching doors and walls. The father attempted to calm her down. However, the mother attacked him, punched him in the face, and kicked him in the groin. Thereafter, she retrieved a large knife from the kitchen. The mother began to pace around the house, screaming and pointing the knife at her stomach. The father stated that he needed to call 911, and the mother held the knife towards her head and threatened to kill herself. The father eventually calmed her down and insisted she go to a crisis center in Lawrenceville, at which she attended several appointments. On February 16, 2025, the minor child was born. On or about March 9th of 2025, the parties returned home from a baptism party. The mother suddenly became violent, breaking pictures, throwing items off the kitchen counters, smashing anything within reach. The father immediately took the minor child upstairs, packed an overnight bag, intending to bring him to a mutual friend's house. However, the mother followed him upstairs, refused to allow the father to leave. The father called mother's parents, who were nearby after the party, hopeful they could assist him with the minor child. After mother's parents arrived, the mother demanded the father hand her the minor child, and when he refused, the mother attempted to forcefully remove the minor child from the father's arms. The mother's stepfather restrained the mother upstairs, and the father managed to move downstairs with the minor child. The mother followed them, and her mother wrestled to restrain her in the kitchen while the stepfather called 911. After police and ambulance arrived, emergency personnel informed the mother that she could go to a hospital voluntarily or be transported under a Section 12 hold. After prolonged argument, the mother agreed to go to the hospital, where a physician issued a Section 12 order requiring mother to remain in the hospital for a psychiatric evaluation. On or about May 10th, the parties met the father's friends at a brewery to introduce them to the minor child. The father's friend unintentionally mentioned the name of one of the father's ex-girlfriends, which made the mother incredibly angry, and the evening was cut short. During the drive home, mother angrily screamed at the father and violently flailed about in the passenger seat for the entire 45-minute drive. The minor child was in the back seat of the car during mother's erratic behavior. On June 28, 2025, the father and the mother traveled to Bethel, Maine for a weekend trip with their bridal party at an Airbnb. During the evening, the father noticed that the mother was drinking heavily and appeared agitated. At approximately 11 p.m., the mother was incredibly inebriated and insisted the father go upstairs with her to the master suite to talk. The father was concerned about her behavior and informed his brother that he may need help. Once in the master suite, the mother angrily spoke to father. However, her words were nonsensical. The father's brother knocked on the door several times and requested the father's presence downstairs. However, the mother blocked the father from leaving the room. When the father reached for the door, she asked why he would leave and falsely accused him of shutting her fingers in the door. The father informed her that he was removing himself from the situation, and the mother punched the father in the face 3 times. This is what was being spoken of in the handwritten affidavit. The father managed to open the door. However, the mother grabbed his arm and pulled him back into the room. The father's brother yelled that he had seen the mother drag the father into the room. Suddenly, the mother became calm and pleasantly told the father that nothing happened and that they were just talking in bed. The father was incredibly scared and fled the room. The father's friend drove him to an inn in Shelburne, New Hampshire. The father was later informed that the mother physically attacked her bridesmaids and ran off into the woods, threatening to harm herself. I mean, this just screams of a mental health issue, severe mental health issue. After father left, the mother arranged for her parents to pick up the minor child from the father's parents' home at approximately 3 a.m. on June 29, 2025. Throughout the day of June 29th, the mother sent the father disturbing text, including but not limited that she was going far away for a long time and that neither she nor the minor child were okay. The father was incredibly concerned and went to check on them and removed his firearms from the house. The mother refused to allow the father to enter the home without her mother present, and thereafter refused to allow him to take the minor child. On June 30th, the father sought to obtain an emergency abuse order pursuant to statute and granting him sole custody of the minor child and ordering mother to have no contact with father or the minor child. After mother was served, the police informed the father that he could pick up the minor child with the police present. The father went to the residence with his sister to pick up the minor child. When he arrived, the mother was upstairs. The mother's mother handed the father the minor child. He took the minor child and brought him outside to his sister. Thereafter, the father went into the garage to look for luggage to pack a few things. While in the garage, the father heard yelling and then several gunshots. The father was terrified, ran out the garage door and began screaming to his sister to run. The father subsequently learned that mother had attempted to shoot one of the officers upstairs. Where there is a finding of a, quote, pattern of serious incident of abuse, the judge must employ a rebuttable presumption that sole or shared custody with the abusive parent is not in the child's best interest, quoting a 2015 Massachusetts case. The minor child has remained in the father's sole care since June 30th, 2025. The father is terrified that mother will harm the minor child. The father's position is that he should continue to have sole custody of the minor child. As the minor child is only 7 months old, he is in desperate need of stability and continuity to encourage his growth and development. The mother is clearly incapable of prioritizing the minor child's safety and welfare, as shown by her consistent threats to harm herself and the minor child, her physical attacks on the father, and attempting to shoot an officer while knowing the minor child was in the area. On or about June 30th, this court granted the father sole custody of the minor child and ordered the mother to have no contact with the father or the minor child. On or about August 25th, mother was indicted for assault. Thereafter, on August 28th, she was released from bail. We went through this before, that it was vacated. She was held without any bail. And citing a Massachusetts case, he says, while there's no definitive checklist of factors to determine the best interest of a child, we consider certain constants such as, quote, which parent has been the primary caretaker of and formed the strongest bonds with the child, which would have been mother up until that, the need for stability and continuity in the child's life, the decision-making capabilities of each parent to adjust to child needs, the living arrangements and lifestyles of each parent, and how circumstances may affect the child. The mother is presently being held without bail. She is clearly unable to care for the minor child. Although the Department of Children and Families opened a case, such has been closed based on father maintaining custody and mother having no contact with the child. The father can provide a safe, stable, loving environment for the minor child and is attentive to his needs, including but not limited to scheduling necessary hernia surgery that mother had previously unilaterally canceled without father's consent. The father is dedicated to ensuring the safety and well-being of the minor child. The father is seeking child support from mother pursuant to Massachusetts child support guidelines. The father is employed as a firefighter. The mother was formerly employed as a police officer. The father's position is that the court should attribute full-time employment at minimum wage to mother for the purposes of child support. Although the mother is presently unable to work, she is being held without bail. She does own a property, gives the address, and cites a case for a party's ownership of substantial assets also may be weighed in determining whether attribution is appropriate. And then he cites footnote 1 about that motion that he filed earlier. The motion is further supported by such arguments that may be advanced in court. And this is a verified pleading. So I don't know. Let's see what you guys' thoughts on this is. Nina said the grand jury didn't indict her. Oh yeah, correct. For attempted murder. That means they didn't believe the cop who shot her, right? He was the only witness. I think they just didn't believe that there was any evidence that she actually intended to murder him, even if they did believe that the gun might have pointed in his. Well, if he said that she pointed it in his direction and pulled the trigger, which I'm not sure because that's what I was hearing some of, then yeah, they didn't believe it. Because if you actually pointed it in his direction and pulled the trigger, but nothing happened, it sounds like they would have indicted on that.
Hey, so you know where I'm at with this?
Where?
I mean, you said it during, the middle of that reading. There are mental health issues that are being weaponized against her. I mean, she clearly has an issue with alcohol, first of all. I mean, just she doesn't handle her liquor well, obviously. I mean, there has been multiple instances where, she gets in this, headspace when she's drinking where, she's not a happy drunk.
That
right?
predated the pregnancy?
I've had various people emailing me just for full transparency so that we have kind of both sides of the story out there, that, there's been multiple instances of her, being intoxicated around multiple friends, family, and she just kind of loses her shit.
Which explains why the court's so adamant that she's got alcohol monitoring. Although I still think there was a reasonable alternative presented to the SCRAM.
Yeah, Hunter. But the bigger issue in this country is that you don't punish people for this type of issue. You don't punish people if they have some kind of mental illness that is prevailing over their ability to be able to function on a normal everyday basis. You don't punish people if they're battling alcoholism. Those are things that require treatment, not imprisonment. And everything that this guy is doing, even if in his mind he's like, well,
I believe she
like
tried
I'm
to
not
kill a
trying to be
guy.
a dick here, right? Like, well, no. The point being that he should have a more global view of what's going on here. I mean, the guy's a firefighter, which in
Right.
Illinois, that means that you're an EMT and a fucking medic. He's got background in this. Firefighters are trained much more than cops are in terms of how to handle situations where there appears to be something else going on, primarily something that might require some kind of mental health care. Like he's acting awful obtuse as to what his education has
Yeah,
taught
and he
him about
once
these types of scenarios.
loved this
It's a
woman.
fucked up situation. It's a really, really sad situation. And, they're doing what we tend to do in this country is they're trying to sweep the problem of whatever her mental issues are at this point under the rug and just throw her in jail or
The
prison.
right. Well, the judge should have. I think even with all of these allegations, should have said, "All right, I do want DCSF to investigate or whatever their version of that is, and to have supervised visitation." Because, like you said, you cannot have this baby losing all connection with their mother. She is only alleged. She's like you said, she's innocent right now. Obviously she's having some mental health issues or was, and there's reasons to take precautions, but at least give her supervised visitation with her child. He gone.
No, I'm here. I turn it off because I think that you'll be able to hear me through the speakers. Yeah, no, 100%. And I think that in there's a couple of things. One, I just want to be clear. I don't believe that the probate family judge that will be handling this is going to be the same judge she's in front of. I could be wrong. I'd be surprised if it was. I don't think so. Those are different divisions, and judges
Yeah, no.
usually, unless it's a really small
No, it should
courthouse,
not
and
be. It should not be in front of the criminal judge. They can hear
right,
evidence the criminal
absolutely.
judge would never hear.
And so the other part of it is that I think that the fellow women are letting her down in terms of like this judge. Like I've never obviously been pregnant. I've never experienced the hormone changes that women experience when they're pregnant. I've never experienced, nor can I ever experience postpartum depression. These are all very real things. And it seems as if they're just being completely ignored in the situation. I think that
They are.
it's one of those things where it's got to be addressed. Somebody has to stand up and say, okay, this is fucking bullshit. This isn't how we handle these types of cases. Everything is not so cut and dry. We live in a gray world, not a black and white world. And this thing is turning into a nightmare. And they're trying to make it even worse. I mean, they're setting her up in a position right now to where if say she goes to trial and a jury of her peers finds her not guilty, now she's walking out of prison, if they're successful on the real estate motion, homeless and without any assets and without any job. And I mean, how are they doing anything in furtherance of what's in the best interest of the child at this point? To chalk it up and say, okay, well, you know what, Kelsey Fitzsimmons, we're done with her. Like, she had her opportunities. We've sectioned her a couple of times, and she just doesn't seem to be able to get right. That's not how this thing's supposed to work. That is not what we need to be doing with people that are suffering from any kind of mental health issues. Like that, it's not the way that it's supposed to work. And unfortunately, in our country, that's typically the way it always works. And we've talked about it many times in our lives, but it took years, decades, really, before our primary county where we practice, before they even came up with the concept and employed, a mental health court where they're treating these things differently. They're trying to get to the root cause of whatever's going on with Kelsey instead of fucking throwing her in prison and just letting her rot in there. So this is a really sad case. It really is.
Yeah. Yeah. Microdot says great coverage. Thanks, Microdots. Not that Dina says Andover is very expensive community. House prices would blow your mind. Check it out. Yeah, sounds like it. Music to My Soul says, so was that his ulterior motive for filing a TRO? And I'm assuming that was to get child support, get the kid and force her to sell the house. I mean, who knows? Who knows? But it was definitely to get an upper hand. And maybe he felt it was needed at the time. I mean, it does sound like her, her parents had to intervene. There was definitely some, stuff going on. Not that Dina again says she's 28, perfect age to have chemical disorders come to life, aggravated by pregnancy. I mean, that's what Bob's saying. Like, these are things that need to be considered. It just makes no sense why they're ignoring the fact that she's led a perfectly, law-abiding, life up to now, and that all of this is hormonal, mental health. I mean, ay. Yeah. So I think that's all the pleadings, right, babe? Well, guys, we in DSN, thank you for your super. Appreciate you hanging with us. Sorry about the the technical difficulties. I would anticipate that this judge's ruling is going to get appealed, and hopefully it gets expedited. We'll have to see what happens on September 23rd, where it looks like there's supposed to be some kind of hearing on this emergency order of protection. I think that it needs to be considered. What also needed to be considered is the mental health detriment to incarceration. In this case, that the judge wants to say, I don't want her to drive. I don't want her to be out of the house to drive to get her urine test. So I'm going to put her, in custody when she is having mental health issues. She's under treatment. She's not able to get that continued treatment. All of these things go to what she refuses to call substantial injustice, or substantial justice.
And babe, that's everything that we have thus far. And I don't know if you want to pull up. So Bradel had kind of commented coming out of court the other day. And I think Tim's a fine attorney. Don't get me wrong here, but when he comes out of court, if I remember correctly, he's saying things like she had an episode, she's gotten the treatment, and now she's perfectly fine. I don't know if that's helpful in this situation where now she's sitting in custody until this thing goes to trial, unless they're able to successfully get this thing reconsidered or put up in front of the judge to where the judge is going to have a change of heart. But now he's on, not obviously court record, but he's on public record saying, okay, well, she's good. Like, whatever was going on with her mentally is now resolved. She's gotten the treatment. That's all under control. I mean, the one thing is that when people dry out, it's obviously going to change her overall demeanor. I mean, if she's not introducing alcohol into her her system, which is clearly an issue for her. And there's no judgment here at all. I drank for an awfully long time, and you had to deal with my bullshit during the time that I drank, and I always considered myself to be a happy drunk, but she clearly had issues where some people, when they get intoxicated, they get rage filled. That's facts. That's how alcohol affects everybody differently. But my point being, I don't know how helpful that statement was to be made to the media. And I know that I think that was the day that they were walking out after basically the judge had said, I'm tossing her in, so I don't know, man.
I can't find his, I did a quick look. I don't see his, like a video of him being interviewed.
Yeah, and as a bit of an aside, different case, Andy Baldwin just texted me. Apparently, and we'll be doing a live, I imagine, tomorrow on this, Mark Lehman, who is one of Richard Allen's appellate attorneys, has had to file a motion to compel because to date, Gull has still not turned over the exhibits from the Franks memo and the exhibits from the motion to correct errors, both of which are going to be prevalent in the appellate brief.
Right.
That is fucking crazy to me.
That is,
like,
it's not.
Dude, she's not turning over exhibits for the appellate court to be able to review and
the record.
For the appellate attorneys to be able to draft. It's insane. I don't know what that woman is doing. We live in just a fucking incredibly bizarre world. Like our world has gone mad.
Yeah.
That's the only thing
for sure.
It's crazy. So keep an eye out for that. We're
definitely keep an eye out for that, guys. We'll go live about Richard Allen. And thanks for joining us. Thanks for sticking with us between the part 1 and part 2. Thank you, mods.
Yeah.
Thank you, Tracy and Mandy. Thank you, Young Jerks. Thank you, Melanie Little. Is there anyone else I need to thank?
I think you got everybody. And then the people, of course, all those that were kind enough to send supers in. We always really, really appreciate that. And please remember to like, share, subscribe. If you're a replay crew, leave a comment. That really helps get us out into the algorithm. This is a case we want to shine a light on. There's a few of them out there that we're following pretty intently. And Kelsey Fitzsimmons is now very much on our radar. So hopefully, I don't know if it's going to be all audio, and I don't know that we'll be able to get any coverage on the hearing for the OP. I don't know how they do that out there. So
and we might
I guess that's
get on a Zoom thing like we did before. But yeah, so if you haven't already subscribed to Young Jerks, go check it out. They've got a lot of information on this case, as does Melanie Little, who most of you know does great coverage. So thanks again to everybody, and we will see you tomorrow. I was pausing because I didn't know if you wanted to say some sort of closing line.
Oh, me? Yeah. Because without you guys, I'm just an old man
sitting around talking to his wife
and driving to the city.